I'm delighted to welcome the Honourable Mr Justice Lindblom, who's spoken to the conference about the first 18 months of the planning court within the administrative court. Sir Keith will be well known as a leading planning practitioner over many years, went to the bench 5 years ago, and as many of you will know, is shortly to take up an appointment as a Lord Justice of Appeal. Sir Keith, what are the essentials, would you say, of good practice in the planning court?
Well, I don't want to be exhaustive here, but I would mention, I think, 5. The first one, and an obvious one, I think, is what I would describe as rigour and realism in selecting and drafting the grounds of the claim, and indeed working out the basis on which it is to be opposed, if it is to be opposed. That's the first thing. And secondly, economy and candour in the preparation of the claim form and the summary and detailed grounds, and in the witness evidence, avoiding, of course, any temptation to re-argue the planning merits. I think that's very important. And then thirdly, engagement between the parties, early and continuing engagement, with a view to reducing and refining issues for the judge to decide. I think that's an essential component of it. And fourthly, good sense in preparing and presenting material for the court, helping the judge focus on the documents which really are central to the dispute, rather than providing the court with documents it really doesn't need to have. And the fifth one would be this. I think skeleton arguments need to be based on, if possible, an agreed understanding of what the main controversial issues are, the history behind those issues, and the essential case law which is relevant to them. Now, if all of those things are done, and done at the right stage, and usually at an early stage or as early as possible, I think things go much better.
I wonder whether I could ask you particularly to focus on what counsel and solicitors can do to help the planning court most in your experience over the past 18 months.
Well, I don't want to be prescriptive here, and I want to emphasise, of course, that what I'm saying now is in no sense to be taken as a practice guide or practice direction, certainly, not even of an informal kind. I want to emphasise that. But recognising, of course, that cases are different and significant cases are different from cases which are not categorised in that way, we can, I think, do certain basic things. Condensing the documents in the case, which can run to several lever arch files of documents in some of the cases, down to a single core bundle, 200 or 250 pages. Usually that can be done, and saves a lot of time at the hearing. Agreeing chronologies and, in my view, in many cases, agreeing narratives of the relevant facts is a hugely valuable part of this exercise. Relieving the advocates actually at the hearing of the need to paint the background in their submissions, and easing the judge's burden in writing the factual part of the judgment, which can take a great deal of time. Agreed issues, agreed propositions of law, agreed bundles of authorities. All of these things are straightforward, provided time is given to them. I would commend those thoughts to practitioners.
Well, one final short point about rolled-up hearings.
Yes.
What are your thoughts on those?
Well, in my view, and I know not all judges necessarily take the same view about this, but I think we can make more use of rolled-up hearings, particularly in the more substantial and complex claims. They can save a great deal of time and a great deal of cost, not least because lengthy permission hearings, if permission is granted, do generate and can often generate an unnecessary duplication of work. There are problems, of course, if one tries to change a rolled-up hearing, change a permission hearing into a rolled-up hearing as one goes along. That's not a desirable thing to do generally, and it can cause real difficulty. So I think we can avoid that kind of problem by confronting this issue at an earlier stage.
Sir Keith, many thanks.
Thank you.